Moving forward from today, these are the words that will echo in your mind. In the bag for Trump. That's how this ground-shaking decision just handed down from the Supreme Court this morning right into the operative hands of Donald Trump and Project 2025. That's how it's being described. In the bag for Trump. Birthright citizenship. It's our breaking story, and MSNBC has the historic details and all the implications of this landmark decision from a supremely tainted Supreme Court. Here it comes, warts and all.
And if I recall, Leah, in the Biden administration, they tried to go to the Supreme Court to have them take up the issue specifically about district judge power and whether they could issue these sort of nationwide injunctions. And the court never chose to take it up then. Why not then and now?
That is part of what makes the court's decision to take this particular case so troubling. The Biden administration was subject to a raft of nationwide universal injunctions for 4 years. They asked the Supreme Court to take up the propriety of nationwide injunctions in cases that probably were less appropriate for nationwide injunctions, like a challenge to the particular rules for forgiving some student debt when you enroll in a university that is the subject of fraud. And the Supreme Court opted 5 months into the Trump administration to all of a sudden declare that now is the time that lower courts lack the authority to generally issue nationwide injunctions. And so I have real doubts about whether the Republican justices on the court are going to apply this same rule to Democratic administrations, or whether they instead are going to say something to the effect of, well, when a Republican-led state is challenging a policy of a Democratic president, we just so happen to conclude that in those cases, nationwide injunctions are necessary to provide those states with relief. I think the fact that this court has been so complicit in putting Donald Trump in particular above the law and basically eliminating ways to enforce the Constitution and federal law against him should raise serious alarm bells about whether this court is kind of in the bag for Donald Trump and the Trump administration. Remember that last year, the Supreme Court declared states could not enforce Section 3 of the 14th Amendment against Donald Trump and keep him off the ballot because of his role in January 6th and the Stop the Steal movement. Now they have told lower courts, generally, you cannot award nationwide injunctions, even when this president's policies are alleged to violate Section 1 of the 14th Amendment. They are attacking the mechanisms for enforcing constitutional rights guaranteed by the 14th Amendment. You add to that their decision in the immunity case, in which they suggested Donald Trump's participation in an effort to overturn the results of the 2020 election was not something that could be subject to criminal prosecution, and instead involved core, exclusive presidential powers that effectively place him above the law. I think that grouping of 3 cases, where, again, the court's 6 Republican justices consistently put Donald Trump above the law, even when that law includes our most fundamental constitutional rights, is deeply alarming and speaks to the extent to which the Republican justices are willing to enable Donald Trump's lawlessness.
I understand that Justice Sotomayor is still reading her dissent from the bench. We also have a dissent from Justice Jackson, who writes in her dissent, the court's decision to permit the executive to violate the Constitution with respect to anyone who is not yet sued is an existential threat to the rule of law. Melissa, your thoughts on just the emotion that we are seeing triggered in this particular ruling?
Well, it seems very clear, Anna, that tempers are high on both sides. Both Justice Sotomayor and Justice Jackson dissenting. Justice Sotomayor choosing to read her dissent from the bench. That's not something that always happens. They reserve that for the most forceful dissents in the cases that they think matter the most. But she is basically into a 15-minute read here, which is one of the longest public dissents that she has made. So she clearly thinks this is really important, and it is likely that we may see something from Justice Jackson as well. And also the cross exchanges between the justices here show that tempers are short on this court. The clip that Julia earlier read from Justice Barrett about Justice Jackson It's a little short, a little jarring in its tone. It's not typically what you would expect from life-tenured colleagues, but it seems clear that at least on this issue, there was a lot of disagreement on this court, a lot of disagreement about the impact of the court's decision here and whether or not this would truly give rise to a failure of rule of law systems. Justice Barrett says that this is only about stopping an imperial judiciary. Justice Jackson saying, no, this is about stopping an imperial executive that is moving very quickly toward something that looks more like autocracy.
So, Melissa, if, in this ruling, they're saying, look, President Trump's executive order on birthright citizenship still, isn't going to go into effect immediately. There's this 30-day window. Does that give you a sense of how they're planning to approach the actual executive order, the merits of the idea of banning birthright citizenship and how they expect it to all unfold in the next 30 days? Will we see another ruling from them on the merits?
Well, let me say this, Anna, this shouldn't be a hard question, even for this court. If everyone on this court can read, and I'm assuming that they all can, the text of Section 1 of the 14th Amendment could not be more clear. That was repeated at oral argument. Justice Kagan mentioned that in her many colloquies with the Solicitor General, John Sauer. It could not be more evident what the framers of the 14th Amendment intended to do. Now, this administration may continue to push at this, may continue to push on who is included within the jurisdiction of the United States for purposes of Section 1 of the 14th Amendment of birthright citizenship. But this is a very clear-cut case. The fact that we are even in a situation where we're going down this road shows how far off the rails things have gotten. So we may see more rulings from this court. I think really what we're going to see is sort of the nature of how any relief might be afforded here by the district court, which now has to be more mindful of how it writes its rulings with regard to anything that this administration does, whether or not this is a situation in which the remedy that the court now declares is extraordinary of a nationwide injunction is actually merited. So I think that's going to be the real force. But the underlying substantive question, that is easy, Anna, and every American should know that, and every American should be alarmed that it's even on the table.
And let me read the 14th Amendment again for our viewers as a refresher here. Quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. We heard the justices discuss the 14th Amendment. We heard them discuss the merits of the president's executive order during the oral arguments. Chuck, is there any gray area there? And why wouldn't they just also rule on the merits in this case?
No, I agree with Melissa. I think it's pretty clear. It's been commonly understood, Anna, that the provision you just read applies with a very narrow exceptions to anybody born in the United States. The exceptions are as follows. One, if your parents are diplomats, let's say posted here from Canada, and you are born while they are posted to the United States, they are not subject to the jurisdiction of the United States. They are subject to the jurisdiction of Canada, and therefore so are you, and therefore you're not a citizen. And then there's another minor exception for a child who's born to parents who are part of an invading army, which clearly does not pertain here. So I do think the language is clear. However, the Supreme Court, in its decision today, did not address the underlying merits. I do think the underlying merits are relatively easy. You know, it's a common principle, a fundamental principle of law that similarly situated people should be treated similarly and, of course, constitutionally.
Constitutionally is a word with less and less meaning and importance each passing day under the Trump, Vance, and vote regime. For these guys, the Constitution, your Constitution, is just an annoying distraction from their ultimate goal of serving their master's vision of a world that doesn't need you, no matter where you were born.